The webinar has now begun.
Okay, good afternoon, everybody. We want to welcome everyone to a wonderful hour that we have coming up. The title being Modernize Your Post-Settlement Process. So thank you for joining us. I'm here with Laura Fetto from Milestone. We have a great group of esteemed panelists that will join us and share some great information for you that I think you will find valuable. I think the four of these panelists total, if my math is right, are probably have total of about 70 years of mass tort experience. So I think you're in for a treat. My name is Marcy Spitz. I am an attorney. I am a founder of Massive, and I specialize, my wheelhouse is in ERISA, and I obtained that knowledge and area of interest from the Department of Labor in Washington, D.C. My first job out of law school many years ago. I was responsible for investigating all kinds of employee benefit plans, including pension and welfare plans. After a great deal of work on the pension side, I transitioned into the healthcare side and learned a great deal about subrogation and the need for lien resolution and for stellar lien resolution services, and established the company that we now call today Massive. With my background, I specialize in the more complicated ERISA plans in addition to Medicare and Medicaid. The Massive was established to help mass tort attorneys, and currently Massive has been designated as the exclusive lien resolution administrator for the Lamacchia mass tort cases. And we are working now with Medicaids all over the country, establishing plans for lien resolution, in addition to Medicare and the other lien holders that hold liens for the Lamacchia participants. So I wanted to tell you personally, I have 3 kids that are in graduate school right now that will become relevant later in the webinar. 2 in law school, had a great summer, and I just finished a half Ironman 2 weeks ago after training for a couple months. So I'm really thrilled that the summer is kind of concluding after some hardcore training. So I want to introduce panelists that we have with us. Trevor Roxette, I'm very happy to have you here today, Trevor. He has been with Davis and Crump for 12 years. He has worked on behalf of 13,000 participants, worked at negotiations and in administration of settlements with the firm's mass torts client. He has 2 great kids that I'm sure he had a great summer with, and we welcome him here and happy to have him. Leslie Lamacchia, who is also with us today. She is part of Beasley Allen in her 17th year of practice. She has been involved in litigated dockets for Essure, Risperdal, and Zyprexa. She is currently working on Lejeune cases and Paraquat, and hopefully that those cases that will come to fruition, and she will see the entire process through from intake all the way to settlement. I know Leslie and I share a love of the outdoors, so I'm sure she's had some great times during the summer. That's where we met, is doing some of our outdoor activities. So we welcome her, and happy to have you here. And I'm going to give the mic to Laura to introduce herself, and Sam and Sindhu. Thank you.
Thanks, Marcy. As Marcy mentioned, my name is Laura Fetto, and I am part of Milestone, located in Buffalo, New York. I've been with the firm for a little bit over 4 years now, and prior to that, I went to law school in San Diego at Thomas Jefferson School of Law before I moved back to the Tundra. And basically, our main goal at Milestone is to provide trusted financial guidance and strategies around settlement to ensure financial security for plaintiff attorneys and their clients. So I'm really honored to be a part of the panel today, and especially honored to be surrounded by such intelligent legal minds. So I wanted to start off by introducing one of our additional panelists. Joining us, we have Ms. Samantha Catton of Alstock, Witkin, Kreis, and Overholtz. Sam focuses her practice on pharmaceutical and medical device litigation. She was previously appointed an assistant attorney general for the state of Florida in Broward County and represented the state of Florida in the prosecution of cases involving child abuse, abandonment, and neglect. Sam was a lead attorney in the unit, and for the office, she mentored new attorneys entering the field of child protection. And during her time there, she was a member of the special litigation unit, where she prosecuted cases of extreme and egregious sexual and physical abuse. Here she gained knowledge, extensive knowledge and experience in bench trials, and she has been and continues to represent plaintiffs in the transvaginal mesh cases, DePuy hip implant cases, and various other mass torts. Sam, it's nice to see you. Thanks for joining us. Appreciate you hopping on the panel today. And then we have Sindhu Daniel as well as our final panelist. She's a principal at Grant & Eisenhofer, and Sindhu focuses on complex pharmaceutical and medical device litigation. She's been handling these types of cases for over 20 years. And previously, she served as a co-lead negotiator on behalf of plaintiffs sustaining severe and permanent injuries caused by the transvaginal mesh implants. She's played roles in the settlements for various other matters and was appointed to the plaintiff steering committee in Xarelto and Ethicon Power Moore Slater MDLs. She is also a member of the National Trial Lawyers Top 100 Civil Plaintiff Lawyers, and this year she was named as one of the 500 leading plaintiff consumer lawyers by Law Dragon. So thank you all four of you for being here today to speak on the panel. Thanks, Marcy, for co-moderating, and I'm going to hand it back over to you for our first topic.
Okay, great. Thank you. Okay, so it's something that confounds me, and I think Laura as well. You know, in any kind of mass tort, at the beginning of the process, you are typically asked to sit on a committee or be part of the mass tort process. You're tasked with, I would imagine, many different tasks at that point in time. Is the task of the settlement process discussed at that juncture? The selection of a QSF, a Qualified Settlement Fund Administrator, or a lien resolution administrator? Or are post-settlement concerns a topic during that time? And many questions bundled in here. And what is most important in considering those kinds of decisions? So, you know, it's like I said, it confounds QSF, you know, and LRAs and how they get selected and what is, you know, a concern, what may be a concern at the beginning. So I'm going to throw that out to you. Feel free to contribute, and I don't think there's any order, and whoever wants to start. So,
sure, I can start. I think post-settlement thoughts are really important at the beginning of a mass tort, and to be able to align yourself with a company, a QSF company or a lien resolution administrator who can handle the volume of cases that you might have in that mass tort. And communicate with them to let them know like what your needs are going to be in the post-settlement process, and also know what their processes are and if they have the right resources to be able to handle, you know, the volume or the tort that you are actually litigating, and to build a relationship so you can trust them, you know, as you go through the settlement process.
I'll jump in too. I know in 3M, Judge Rogers actually created a settlement committee. So I think that's now like a new process in place, because I think they understand that, you know, once a settlement is announced, it moves so quickly, and you really do need to put processes in place to gather information way beforehand. And I know every settlement that I've ever been involved in, that is always the goal. I'm not saying that we ever get to that goal, and you always think you should have gathered this information previously. But I think, you know, we're learning from our mistakes, and certainly judges are seeing that as an issue, and they've created these committees that actually report at the CMCs, the case management conferences. So I think the judges are seeing how important settlements are, and starting the process of even interviewing different lien resolution companies. I certainly haven't heard of, in the very beginning of a litigation, anything about a QSF, just because that seems maybe more in the weeds, and maybe the settlement committee is actually doing something like that. And it probably seems really premature to discuss that with a defendant or anything like that in the very beginning. But certainly in these huge cases that we're doing now, like 3M, like with 240,000 plaintiffs, it's a situation that's certainly very important, and Judge Rogers definitely wants to hear about it. I think it's even in the Phillips CPAP as well. These settlement committees are created. So I think it's really something to think about in the very beginning.
Yeah, I agree with what Cindy and Leslie said, and I think that it's something we all should pay more attention to. I think it's something that we've got to make a better effort. I have an example. My firm recently had a small mass tort that it was really just us and another firm. We had about 2,000 clients, and I'm still kicking myself for not getting on lien res and the QSF much earlier in the process, especially lien res, because now I'm in this post-settlement period where we could have made a lot of progress on the things that we're now dealing with over the last year, but we've got this built-in delay before we're going to be at a point where we can disperse any funds. And I think that's really what it comes down to, is trying to get your clients their money as quickly as possible, and at the same time get your money as soon as possible. And that's really where I think the early efforts come in.
Yeah, I don't think I have much to add. I think three of the panelists have named it pretty well. The only thing I would add is just kind of piggyback on something Cindy had said, which was getting a lien resolution specialist or lien resolution program in place early. I think that's not only based on the court understanding that this is going to be an issue. This is a process that should be started sooner rather than later, because it is something that's going to need to be done one way or another. But in addition to that, I think it also needs to be started earlier. The process needs to be started earlier, because the actual process for getting these actually resolved through the different agencies and organizations is becoming harder. Back in the TVM days, there were global resolutions that were put in place with Medicare, Medicaid, things like that, that made it pretty easily and clear cut based on different data points on what those numbers were going to look like. That goes to so many things beyond just the initial resolution. So getting that in place, though that's not the case anymore. I think Medicare got burned a little bit by that, and they haven't been kind since. So I think getting the lien resolution stuff in place earlier is helpful, because then you know what you're dealing with on the back end. It also goes towards, for plaintiffs' attorneys on here, actually negotiating those settlements and looking at what all of that plays in. This is all something that plays into it. So yeah, much with what everybody else is saying, the earlier the better, and the more transparent about it, the better.
And Sam, going off of that, starting earlier, the better, of course, and learning from past settlements and how those were handled to better, effectuate things going forward for new ones. How do you think, things within your control versus things out of your control play into that? So like as far as information and data collection and things that go towards both the lien res admin and the QSF admin, who will of course be utilizing all of that information, but what do you think you can do? I guess we can focus on the things out of your control.
So I think we all know, and everybody here knows who's worked on settlements, there's a lot that's out of your control, and a lot of pivoting that happens even throughout the settlement process. Even once you're in settlement, there's a lot of pivoting and things that change. So you have to constantly adjust. For this, I guess what I would say is there's a core set of data that's always going to be true and factual. A lot of it's demographic information, a lot of it's stuff that can be gathered during intake. A lot of the information can be done necessarily on the front end of any litigation when you're coming in. It's simply a matter of tracking it. I don't know about anybody else here. I'm assuming since, Sindhu and Trevor and Leslie, all you guys, we've done settlements, so we know. I'm a bit of a data freak. I love my data. I love a good Excel spreadsheet. I love everything there. And a lot of the lien resolution specialists you work with, that's what they want. I'm about providing and being efficient. So the more data you can collect up front, the better. There's a lot of data you're not going to know. For example, what injury dates, what's going to actually trigger the resolution process, what they're going to have to actually resolve. So those are things that obviously can be added later, but having a good track of what those are on the front end, I will say that it's going to vary based on intake and what the actual product is, what the tort is. If it's a pharma case, if it's a products case, it's different information, right? But there's always the basics, social security numbers, always going to need them, date of births. And I can't tell you, and I'm sure everybody here knows, providing the last four of a social, while I understand the security measure for it, at the end of the day, you're going to have to provide the full one. So efficiency, put it up front, right? Date of birth, full names. If you're married, making sure that ongoing communication happens. So if names change, people get married, people get divorced. I've had one client who just decided to change her name, much like Prince, right in the middle of everything, to a symbol. Don't ask. It's very strange. But it happens, right? So this is information that can be updated, and you can have your ongoing sheets. Everybody knows that when you submit for lien res, you have this is our client, these are our clients, this is the factual data you need, this is the demo information, this is what we're going off of to get the process started. All of that stuff can be done, so you can walk into lien resolution, you can walk into that portion of the settlement. And I would honestly say, and somebody prove me wrong on this, that lien resolution is one of the first things you should get started before anything else. QSF is, I would say, necessarily the second, but the lien res, because it tends to take the longest to get done, and inevitably, and I'll put it to Trevor and Sindhu and Leslie, it tends to be sometimes a thing that holds up distribution.
Absolutely.
Yeah, Sam, I would like to take you for dinner when you have a chance. So I appreciate it. And I would love to see your spreadsheets and your information. I mean, it's like music to my ears to listen to an attorney speak about the value of the information that we are seeking all the time, that, and the early start. I mean, the early start is absolutely a given. But, I had also, a couple questions here, but like Trevor, you had mentioned in the conversation with me about plaintiff fact sheets, PFS, and gathering this information, this pertinent information for lien resolution, for QSF. I mean, so that we are not, delayed in performing the lien resolution process, and concern of defense having too much information. When plaintiff fact sheets are used, which they are not mandatory, is that correct? They don't have to be used all the time.
Case. No, they're not used in every. Usually there's some sort of exchange of information though. Okay. And I think the discussion that you and I were having, and I think Leslie was involved too, that there is sort of a balance between what we give to the defendant in these cases and what we need and what we ultimately are going to give to the lien resolution administrator. And what we're seeing in some cases is a census procedure, not the census procedure that we're seeing in like the CPAP and the Zentak litigation, but more of a plaintiff's leadership census to gather information about the entirety of the universe of cases. And I think that's an important part of at least from a leadership perspective, an important part of getting these cases ready for a future settlement, having that information so that we can start the process of lien resolution at a more global level versus, because that's the nightmare, is I can control my firm. Someone asked about the things we can't control. I can control my firm, and Sam obviously has all her data and I've got my data, but if we're in leadership, what do we need to get from all these other firms that have cases? And that's really where the nightmare is getting that data from those firms. And that's why I think we've got to start that process early. It's maybe not in conjunction with the PFS process, but can be somehow piggybacked on that, I think.
Yeah, I mean, and I have another question related to all of this as well, and I appreciate that, Trevor. You had mentioned, I think it was Sindhu mentioned the 3M and Judge Rogers and the fact that she appointed a settlement committee, and so that they were thinking about these ideas, these concepts from the start. The titles of the committees that are formed at the beginning of each mass tort are those only mandated by the judge, or does the steering committee or the PEC have the ability to create a settlement committee as well? And the other reason I take it one step further, which we can get into in a little bit, on the LDCs, the Learning Development Committees, and teaching them, that in a mass tort process, it would behoove them to think about the settlement and form a settlement committee as well, even if it wasn't mandated by the judge. I guess I'm curious as to how the committees get assigned and which ones, that are delegated, and are those only assigned by the judge or by the PEC? So a lot of different questions there, but who determines the different committees, and is that something that's difficult to do at the beginning?
I think that, each case, I think unfortunately can't pigeonhole it. Each judge is so very different, right? Some judges like to accept slates of attorneys for leadership so that, those slates generally kind of work amongst themselves and decide who's going to be on which committees and everyone's area of specialty, and so that leadership committee may decide to have a settlement committee, or they may just have a settlement person in the very beginning. Additionally, like big, huge cases like 3M, for example, the judge is very involved in that case, and she has decided and created these roles and even interviewed all of the plaintiff's attorneys to determine which position they would be in. So it's even, I think every judge has their own different approach on each of these MDLs. So I don't think there's any, unfortunately, I wish I could give you like a standard response, but every single case is going to be so very different. And I think the roles in which, but I think settlement, like everyone has said, is so important from the very beginning, because either they're going to be settled, they're going to be settled in some fashion, whether it's half of them, a quarter of them, just based on injury. I think at some point they will all get adjudicated in some fashion. And that information that you're talking about, these plaintiff fact sheets or census documents, like Trevor said, I think it's really important. And one thing that I would stress to everybody who ever listens to this webinar is, like, our duty as plaintiff's attorneys is not to just get cases and sit with them. It is to investigate them. And just at a basic prima facie level, we should know whether this person took the drug or device, used it, had it implanted. We should have some evidence of that. And we should have, the injury. We should know those two things. And we not just know it that because the plaintiff told us. No, have the medical information and have that to back it up. And all of the other risk factors and all of the other issues, you'll get that. But at a first blush, we should not be filing cases that have absolutely no merit. It hurts our entire industry. Like, look, we've all had to file a case. There's a statute issue. We all have that issue come up. But that should not be the number of cases that get filed today that have absolutely no medical records, nothing to substantiate the claim, and it has no statute issue. I think it's really hurting our profession. And I think we really need to remind everybody, of our duties and obligations, because it hurts the entire profession. It makes us look bad in front of judges, and the defendant can then bring up more and more examples of cases where we're just filing 10,000 cases, but they're really only 2,000 legitimate cases. So, I think it's really important that we remind everybody, what our duties are, and it helps with lien resolution ultimately, because then the real value cases and what we should be going after, and then the population.
Right, and that adds to what Sam was saying earlier, is know your set of data in the beginning and really appreciate the intake and understand who your claimants are. But to add a little bit more about the committees and settlement committees, I've been on 3 plaintiff executive committees. I've served on one with Trevor. We didn't have a settlement committee, but for Jewel, we did not have a settlement committee, but the judge eventually appointed a settlement special master. So even though there's not a committee, the judge appointed a settlement special master where the PEC, does speak with the special master regularly to facilitate, some sort of settlement negotiations. And currently in Paraquat, we don't have a settlement committee, but you do have, your subcommittees within all the executive committees or the steering committees.
And Leslie, when you're going through those, conversations, whether it be a specific committee or it's a special master and the topic of, a lien res admin or potentially, there down the road a QSF admin comes up, what parts of what part of that selection process do you think is highlighted the most when going through the options and selecting those types of administrators? What is the most important thing that is being sought after when those discussions come up, and who's going to be chosen to fill those shoes?
I think I want to, ask Sindhu a little bit more about that, because with eSure, it was so large, and I think it is law firm based and not necessarily, committee based or PEC based. So Sindhu, do you have anything to add about that with how the eSure settlement went, specifically with regards to who was chosen?
I wouldn't. So in eSure, it was really based on who could handle the job, right? Because it's certainly not law firm based or anything like that. It's just whom there are few people out there. Unfortunately, it's a small group of people who can handle this type of volume. And who specialize in doing this type of device issue. And certainly in eSure specifically, it was a population. Bear specifically marketed that product to people who were more indigent in nature. And so we knew there would be a lot of Medicaid, Medicare issues. So we had to have somebody who kind of specialized in that and who could help quickly resolve those issues. So in that sense, it really has to do with each case that we're involved in. I serve on, I think, 5 different PSCs, and I think every single case is really very different on how we decide to pick them. But look, ultimately, it's based on the leadership's level of experience with each of these companies. There is a lot of sitting around and saying, hey, so-and-so worked so well in this case, and I think it would be a good fit here. So-and-so worked well in this case, and I think it'd be a good fit here. To me, I really think it's really kind of based on the product. For example, if somebody's done a lot of hip cases, and now you're doing a hip replacement, bilaterals, whatever, or if it's just product in place cases, you'll have one company that you use versus drug and devices. People have used, other companies. So I think it really kind of depends on the situation. And is there going to be a lot of this PLRP, this like private lien resolution issues, and then you'll use a specific company for that. So to me, it's very case dependent. And I don't think there's just one company that fits the bill for anything.
Yeah.
That being said, Sindhu and Leslie, the experience, I hear the product, the relationships with the various lien holders. In the case of private lien resolution programs, if you have several thousands of Medicaid recipients, so those kinds of relationships with lien holders. The fact that this webinar today is about the bifurcation of lien resolution and qualified settlement fund administration and the inherent advantages to having maybe 2 separate entities that specialize in those kinds of functions for a mass tort settlement process. And is there, I guess, how do I phrase this? Your experiences that you've had, good or, positive or negative, with one entity that handles all of this post-settlement process? Can you see where there are, it would be advantageous to have 2 separate entities? We are working with Milestone and in collaborating on some of these programs and information sharing and making sure that where one may be lacking in something, the other has that information and sharing that. And where you have one entity, there may be other scenarios. Have you experienced that kind of that situation where you have one-stop shopping, where you have one entity.
So I
I'll
don't know if
jump in.
that was, go ahead, Trevor.
Sorry, Sam. I'll just say that we've all worked with shops that do it all, and I think that we've had good and bad experiences, I'm sure, with those companies, and I don't want to disparage anybody, but I certainly see an advantage in there being a division. I think that there is, and this may come down to how we talk to our clients and what information we're able to convey. I think when the QSF administrator is also your lien resolution administrator, especially in a case where the QSF administrator is making any kind of money off of the interest from the money that sits in the QSF, I think you have an inherent conflict if they're also the lien resolution administrator. I don't think that any company out there would do that on purpose, but when we're talking to our clients and they're asking, well, who's making the money on this $10 million that's sitting in this QSF? Unfortunately, the honest answer may be the QSF administrator, who is also the lien administrator. I think that's a problematic answer, and not necessarily a situation that any of us want to be in. So I definitely see that as an advantage to having two different ones. I also think that it's the reason why it's sometimes nice to shop at a local market. To go to the local shoe store and the local grocery store versus going to Sam's to get both your shoes and your groceries. There might be a little more specialization with the shoes from the shoe store. And I don't want to get too lost in my analogies, but I think you guys can see where that goes. So anyway, I think there's definitely benefit. Now, the one caveat to that is I think it's critical that the two companies have a relationship or be willing to form a relationship, create a relationship. Those two companies have to work hand in hand, and they've got to be able to really cooperate and do well together.
Yeah, I'd actually agree quite a lot with what Trevor's last statement, which is if there's going to be separation, which I do believe there's a place for it, there has to be some kind of communication, because the biggest drawback to any situation, whether it's QSF or lien administration, is communication and the sharing of information, because one necessity, this is every area of settlement, and there's a lot of areas that so many people never even think about that have to be done before you get to that final stage where check actually goes out. They're so interdependent on everything. And when there is that separation, there needs to be that communication so one knows where the other ends and the other picks up. I agree with what Trevor said. I think there's space for both. I've worked, like he said, with both the kind of one-stop shop, and I've also worked in ones where we outsourced the lien administration and QSF that were separate. I think there's a place for it. I think it's also who can handle it. I do actually also feel that there are certain litigations that kind of naturally streamline into the natural separation because of the types of liens that you're going to see. So for example, if you're going to see a higher level of death cases, or you're going to see a higher level of bankruptcy cases, you're going to see a higher level of certain things that you want to incorporate in, it might be easier on the firm itself to have a one-stop shop. However, that's not necessarily true. I think it's very dependent on the case that you're actually dealing with. When it comes to the separation, what I appreciate and where I think there's absolutely a space for is when you have one entity doing the liens, there is a delineation line, right? There's a line of great delineation that says, I stop here. This is where my authority and where my knowledge stops. And then I pass the buck to somebody else. I pass this next stage to somebody else. And everybody on the panel can attest to this. Things go wrong in settlement all the time. There is human error. It happens. And you pivot, you deal with it, and you move on. You need to know where to go to hit those pressure points, to free it up, to make sure that the settlement doesn't sit, that it keeps moving forward, that you can actually move it forward. And to do that, you need to know where to go. You need to know where those pressure points are. You need to know where to go and get it cleaned up. And that's part of the constant problem solving that goes along with settlement in and of itself. And when you have a separation between liens and QSF and bankruptcy and probates and all these different things, it tends to clue you in on where you need to go. But it also brings up the need to have those relationships interdependent upon each other as well. So you're not being called for every little thing that goes wrong. So that's where those relationships that Trevor brought up, for me, really come into play. And if those work well, then the streamline and the efficiency of the settlement itself will go well.
And Sam, that part of communication and that pivoting when you need to is really a huge portion of transparency, just, between the two branches. If, you're working with a lien, resolution admin and a QSF admin separated, that's great, as long as they're sharing all of that info back and forth, and especially, down to the most important thing, which is the client. So if I'm working with someone for settlement planning and I can only take them so far, and there's still an outstanding lien, and that's holding us up from, implementing this plan that they've worked so hard to become comfortable with and that we've designed together, it's really frustrating when you don't have answers, and it's even more frustrating when you go to seek those answers and you still don't get any. So I think that that's another huge thing too, is that lack of transparency at times, and then especially a lack of oversight.
Yeah.
I also think it's really important to note that we all have a different volumes in our dockets, and that when you're talking with these companies who are going to handle, the lien resolution or the administration of the settlement, is that you're going to be treated the same, even if there's, one firm that has 10,000 cases and I might only have 500. I don't want to be at the back of the line just because someone else has 10,000 cases. Like, I still want to get paid, my clients still want to get paid, and we still deserve to be, taken care of by the company as well. So I think that's really important in the selection of who, the company that you choose to work with post-settlement.
In my experience, I've worked with both, companies where we do one-stop shopping and have split. And while I certainly don't want to mention names, but I will say, not because I'm just on this panel, but Milestone, we worked with them in East Shore, and there is nothing like, as an attorney who's, these women who were held up, their liens were held up because of COVID, right? Because all of these Medicare, Medicaid, all of these offices were closed down. And so they were nothing but mad. Right. So when you get that call on Friday at 5 p.m. that, we were able to get their liens resolved last minute and they want their money, and if you're working with a company who's managing your QSF who's saying we're only going to do distributions twice a month, it is like you are in panic mode, because you start to think like, let me see if I can wire you some money personally because these women are not. It's not just about them being upset. And sure, of course, we absolutely want to help people who are going to be homeless. And that's what we struggled with as well. And financial responsibilities, they had children, all of those things. But, personally, when they're saying, I'm filing a bar complaint against you, if I don't have my money this weekend, when you are working with people at Milestone who understand that issue and the severity of it and the urgency of it, they wired money to people last minute. I mean, they worked on Friday, Saturday, Sunday. I mean, everything they could to minimize the stress that we had. And that really meant a lot to our firm personally. And there was never a situation, well, sorry, you guys are, we already gave you a distribution last month, so we can't do it again now. I mean, it was done just spontaneously. And I cannot recommend finding a company who manages your QSF enough, because I don't know of any case that I have ever been involved in the settlement where there is not one unhappy client, right? I wish that wasn't the case, but when you need to get money to them immediately, that's who you need to deal with. And I would just say this too, like, I think the education involved in lien resolution and what it takes really needs to be done with all attorneys and your plaintiff plaintiffs, because I don't think people understand the thankless job that lien resolution is. There's no attorney who's happy to have to explain to clients, oh, how we're taking your money. Yeah, you paid your insurance premiums, you work at a job, you work really hard, you paid your insurance, and now you had an injury, and now they're going to come get some of your money too. It is the most difficult conversation. So, and there's nothing thankless about, there's nothing like happy about a lien resolution company. We don't, as attorneys, say thank you enough to them that they've resolved like 90% of our docket in liens, right? All we're worried about these last 10 squeaky wheels that we constantly like kind of have to worry about. And I think, you know, we as attorneys aren't mindful enough of like the thankless job that it is, because, you know, we're happy to get the money, and then we're just not happy to have to explain to clients all the time about how much money that's going to come out of their settlement. So I really do think that we don't appreciate, you know, how much lien resolution and how difficult it is. Especially during COVID, it was extremely difficult.
I 100% agree with, I second what Cindy said. It's a thankless job, and it comes a lot with screaming and yelling, not just from clients, but from attorneys as well. You know, it's a huge thing. And I will say this to tag on to that. It's not just the thankless job that they're doing, but it's the relationships that the lien resolution companies themselves have to build with all of these different agencies. So if there is a problem client, like Cindy said, that needs to be escalated, they have the contacts and those connections to make that happen. We've all had it where we've had those clients that are just on your call sheet every single day, if not every single week. And you know a bar complaint's coming. You know they're going to call the AG to open an investigation. You know all this going to happen. And you need to have confidence in the resolution group that you're working with, that they have those connections to say, look, we really need to get this escalated. This one needs to get handled quickly for many different reasons. And that's important when making those choices. So yeah.
I think one follow-up that I would add to what both of you are saying is that it's important that we as attorneys have a good relationship with the lien resolution administrator or the QSF administrator. I think that those squeaky wheels, it's important for us to be able to get quick and accurate updates on those. And I know Massive, having worked with them quite a bit. I'm not just tooting their horn, but it's easy to find an update. You can get in their portal and get an update, or you can email somebody and say, hey, can you give me some more details on this? Because the worst position to be in is telling a client, I'm waiting to hear back from the lien resolution administrator, and I don't really have the information you're looking for. Those squeaky wheels, you've got to be able to quickly address their concerns, or else it starts to, especially in this climate that we live in, they start to think that it's all a scam, and you know, if you can't give me this information, you've probably already stolen my money, and that's the source of the bar complaint. So early on in the process, you got to make sure you've got a good relationship with whoever you're working with, and not all those relationships are going to be the same. So find somebody that treats you right.
Yeah. I think in having a portal, you said, Trevor, having a portal is really important where it's live, right? And not waiting 2 weeks to get an updated lien resolution letter or a ledger, I'm sorry. So not waiting that amount of time, because what the lien resolution company doesn't understand is that, you know, we're getting calls like nonstop, you know, where's my money? You're keeping my money, you're stealing my money, right? We're never going to see our money, you know? So yeah, I think having a portal, you know, is really important for us to stay informed.
And that goes to what Laura was saying about transparency as well.
Mm-hmm. Absolutely.
Yeah, I appreciate all the comments on that. You know, there's so many different themes that resonate, you know, getting started early, establishing relationships with lien holders, having good relationships with our firm attorneys. And, you know, I can just speak for myself, you know, individually and for our company, you know, the number of cases does not impact, you know, the degree of commitment, you know, and the degree of transparency and desire to communicate accurately and effectively with any of the firms. I think that is so important, you know, and you feel passionately, you know, I we work in partnership, and I feel like that's such an important component to the mass tort process. You attorneys, the four of you, and what you represent, to work so hard for this pool of plaintiffs, and then for lien resolution and QSF to not only delay, but also not to reduce the commitments, the obligations from those settlements after you've worked so hard to obtain them. You know, the working with the lien holders to reduce them as much as possible, you know, whether that's one case or 10,000 cases, you know, and we all know that, of course, that, you know, setting expectations for the plaintiffs in your cases, you know, because it is hard, very difficult conceptually to explain that they pay for healthcare, you know, benefits and then have to go back and turn around to pay them again, is the way that it is interpreted. You know, how can we owe them money, you know? But there is an inherent obligation by you as attorneys to make sure that the lien resolution administrator, the QSF administrator, that we are handling all of this, you know, properly and as zealously as you are doing the negotiations to negotiate that settlement. So, you know, in terms of passion, in terms of commitment to clients, the same degree of passion and commitment, I think, has to be part of the services, you know, and I appreciate the fact that, you know, that you've said, and somebody, I think it was Cindy who said, it's a thankless job, you know, I mean, but a very important function, you know, a very important job that we take very seriously. I think, you know, lien resolution administration is a very serious function because of that, because those dollars make a big impact on those plaintiffs, you know, to avoid homelessness, to avoid it timely as well. You know, I mean, if there are dire circumstances, which often there are. So I appreciate the recognition of the value of the post-settlement providers and services. You know, I think oftentimes, you know, it seems so far off. Many attorneys don't value those kinds of services. And again, getting back to the, you know, Judge Rogers and the 3M situation and appointing a settlement committee to start early on to thinking about what information is needed so that we can get those distributions to the clients as quickly as possible, so we can determine the lien values as quickly as possible as well. I know we're probably getting close to the end of the hour. I do want to ask about the learning development committees that I spoke about earlier, because, you know, as I think it was Sam who said, you know, educating attorneys, even seasoned attorneys, on the post-settlement process is so important, you know, but certainly I have 2 kids in law school. I see how they are learning, and the most valued learning is from, you know, more senior attorneys, from some of the clinics that they're involved in, from their summer internships, you know. So I think that in the mass tort process, that may be harder to get that education to the younger attorneys, which I'm seeing now and hearing from the judiciary how important learning development committees are, so that they can shadow more senior attorneys and have opportunity to argue motions and be a part of the process. And Milestone and Massive are both very committed to that education process. I am a lifelong learner. I'm learning from you, learning from Milestone, learning from the judiciary on all of this. And I think it's very important to relay that information. What is your sense on, in your firm's maybe experience, or your experience with learning development committees? I mean, whether that it's a formalized process or not. I mean, is that something that you believe in, and what we can do better, maybe what you'd like to see? Mass Tort Made Perfect, I know, is holding a learning LDC segment that we are going to be a part of, and we're really excited about, you know, and love to hear some of your thoughts on that.
And just to hop in really quick, Marcy, before we dive into that, because we have about 12 minutes left, if anyone, any of the attendees have questions that they might want to pose to the panelists, you can actually type them in the question box on GoToWebinar, and then we can have those prepared for the last few minutes when we're done wrapping up this LDC chat.
Thanks, Laura.
I love that they implemented an LDC in Zantac, right? I mean, I was so excited, you know, to see younger attorneys, you know, be part of, you know, a committee where there's so many experienced lawyers. It's almost like a form of mentorship, right? And I love that they implemented that. So that's what I can say about LDCs.
Yeah, I mean, I think it's a great, whoever thought of it, it's really amazing. I wish I had been on an LDC in the very beginning. You know, I was just lucky enough to be appointed by Judge Fallon, who saw the need for change, right? And I think it's certainly especially helpful for women and minorities, and you know, solo practitioners who want to break into a field that is very, very, you know, large firm oriented. You know, it takes a lot of time, effort, money, resources to be a part of mass torts, and to have the ability to learn it and be on an LDC is certainly, I know in the Phillips, the CPAP litigation, you know, the judge takes it very seriously. They even report also at case management conferences, and she wants to know, you know, that they're be given real an education, and they shadow members of the PSC directly and kind of learn each and every aspect of a case, which I think is so invaluable. Because like you said, Marcy, like unless you're doing it, you don't know it. And I've been doing this, like I think about 23 years, and I learn something every day. So I think it's really important to keep learning, and certainly for people who are just starting in this business, it's a great way to really get a hands-on experience.
I'd add that one addition to that, I think that within our own firms, we can do a better job too. One thing we've been trying to do here at my firm is to include some of our younger lawyers in discussions with QSF administrators, lien resolution administrators, not just here, you do the work, but from the very beginning, that first phone call with the company we're going to work with, they're on the phone call with us and a part of those discussions. So they know not just that we have to do this, but what it means and some of the more nuanced details of the process. And
why
that's how I learned, yeah.
Right. And why we're doing it, right, Trevor?
Why
Because
we're
some
doing it, yeah.
lawyers are just doing the work, but they don't know why, right? They don't see the big picture like we do, because we've had the ability to, you know, see through to settlements and everything.
Mhm.
So I like that they're understanding the why we're doing what we're doing from the beginning.
Yeah.
I would add that I think these committees are great. I wish they had been around a little bit earlier, kind of like Cindy said. I think that would have been wonderful for me as well. But what I will also say is I think a level of understanding and a level of education about what settlement is. I feel like mass torts is so, and I'm speaking from a mass tort point of view, is so litigation heavy. It's so litigation centric. Very few people realize that settlement is equally as important as the front end litigation as well. And there are a lot of attorneys in this field and in this space that are just like, okay, litigation's there, let's just pass it off to some staff, let's get it done and just move it along. There's so much complexity that goes into the back half that you don't realize that it's something that should be going on. And I think awareness of that is starting to come out a little bit more. I think there needs to be more education, more exposure about that, and the importance of the role of settlement and all the different wheels and stuff that it plays, how much it affects so much of the rest of the litigation, not just with the younger attorneys, but some of the older attorneys as well, because we're so litigation centric. That would be good to see as well.
And just piggybacking on that, Sam, I think it's really important that you brought that up, because I think even defense attorneys, right, like the judge and the defense attorneys don't realize the amount of days it is going to take to resolve some of these issues. And, you know, the master settlement agreement gives you like some of these deadlines that are so,
Yes.
and that we can't possibly meet some of those deadlines. And
Yes.
it's really important that defense attorneys understand the obligations that are involved in getting Medicaid and Medicare resolved, just that, and then all the private lien resolution, and then convincing all of your plaintiffs to understand all of that and understand all the expenses involved. So I think that just almost an education day, just like there's a science day, you almost need
Yes.
like a settlement course, just for the judge, the defense attorneys, plaintiffs attorneys involved too, right, who are making these master settlement agreements, to say, yeah, 60 days is not going to cut it to get this resolved. It's going to have to be a big window. And once we get that those cases resolved, I need that money immediately. I don't want to hear
Yes.
about these long time, because our clients have already waited such a long time. And I think us, we as attorneys remembering that, and just defense attorneys kind of understanding the positions that we're in, because at that point we're no longer adversarial as much when we're at the settlement stage. So I think we could work together better on some of those issues.
Me and Cindy were speaking the exact same language. I know we all are, but that's exactly what I was trying to say. It is so important to have people who are actually at the table negotiating these settlements, people accompanying those who actually have done settlement, who understand what it's going to take to get this to happen. I can't tell you how many times early in my career I was handed an MSA and said, all right, let's do this. And I'm like, whoa, this deadline is almost impossible. This is horrible. What is, and it simply comes from people who genuinely don't understand the multitude of protocols and processes that have to be done, and how they all have to be done at the same time, and how much juggling goes into that. There are timelines and there are limits to those. We're dealing with government agencies, we're dealing with private entities but we have to build in timelines. I mean, there's timelines for responses built into PLRPs. Like it's everything is timeline oriented. Cindy, you couldn't have said it better. I completely agree with what you're saying. I would absolutely agree that it needs to be happening at the beginning so they understand what we're looking at and what hurdles there are on the back end as well.
I love the idea. I heard you say the science day or settlement day. And I think that sounds brilliant, and maybe the possibility for a future, addition to the process. I mean, I really think how amazing would that to get all of that kind of hashed out, earlier on in the process, looking at the MSA and diving into some of those issues. So yeah, that is, again, the learning that we can, that we take away from these kinds of events where we are talking and thinking and learning from each other is invaluable. And outside of the LDCs as well. I mean, even for, attorneys that have been doing this for a long time, I think there's a great deal of progress always to be made. So I appreciate all of your perspectives. So.
Likewise. And I think, just because we have a couple minutes left, we've pretty much come full circle as far as, the challenges and some of the solutions that we could come up with, for mass torts moving forward, and the selection of different administrators. But if, each of the four of you had to leave our audience with just one kind of general concept about everything we chatted about today, Sam, would you mind going first? Just what you would leave our attendees with before we all have to wrap up?
Sure. There's a lot we covered. I guess my thing, this is something that I was told as a very young attorney back in my AG days. Ask questions, find attorneys. They don't have to be in your firm, people you trust, people you respect in their practice, people occupy the space, have ownership in that space. Ask questions. You're never going to know. Don't try to make something up. Don't make it more complicated. The best thing you can do is make your process as efficient as possible. And you need people who have experienced a lot of different ways of doing that. Ask the question. You might not get an answer, but you might. And if you do, that's only going to help you get educated more. It also helps you keep learning. There's always new information coming out, and different people are on the front end of that different information. Ask the question. Pick up the phone. I'm available. I have friends that call me all the time. Can you explain what this means to me? And I'll take the 10 minutes and I will explain it, because it's important. It's important for knowledge going forward. So I guess that's for me. Ask the questions.
I'll jump in and say, I think the most important thing, like Sam had said, is really gathering data about your plaintiffs. And, that data informs the decisions that you will make regarding choosing your lien resolution group, choosing your QSF administrator. I think all of that information is what I wish we could have at the beginning, even in the middle of each litigation, that I think is really an issue that's coming up more and more. Additionally, I would add just the education component involved for our end, having, working with different lien resolution companies and QSF companies, just understanding and setting real attainable deadlines. Because I think the hardest part in all of us, because we're conveying those deadlines to our clients, we're thinking of those deadlines internally for our projections financially, and lien resolution companies giving us real deadlines that they can really get. Like we can resolve 90% of these in this deadline and this time that are real and attainable, as opposed to just wanting to sell something and us wanting to sign them up. So I just think the education component and the data, to me, are really some of the best things that we can get from any case that we're involved in.
Thanks, Sindhu. Leslie?
I think it's the same, or else it's going to be a broken record. It truly is. Educate your staff about the process. One thing, we didn't really talk about, it's just the education of subrogation and medical lien holdbacks, and telling the clients what they are, spelling it out, sending them a letter, explaining the whole process. The same with your team. So education for me regarding the post-settlement process is really key.
I think mine is similar to what Leslie just said. It's how you communicate with your clients about these post-settlement aspects that we have to go through. And I think it's important to under-promise and over-deliver. The worst thing we can do is tell our clients that some deadline or some projection that we think they want to hear, because then they're just going to be disappointed and they're not going to trust us. I think you've got to, I don't think you want to exaggerate it, but I think you have to be very realistic as to when they're going to get their money and when these things are going to be completed. Otherwise, you risk real problems with the clients.
Right. And I'll leave it to Marcy to officially close us out, but I really appreciate all of you joining us today. And on behalf of Milestone, it's been an honor to be a part of this, and I just really appreciate you all taking the time out of your schedules.
Thanks for having us.
Thank you so much.
As well. Learned a great deal. I hope our attendees did as well. And it sounds like our four panelists and Laura and myself learned a great deal. And we will have on the website ways to get in touch with each of us. Feel free to reach out. We talked about so much today, but so limited in many ways as well. So I am all about the learning process and answering questions and anything that I can provide to newer, older attorneys on, anything lien related, ERISA related, anything that I can possibly help to help educate this world and the value of these services and how important it is to collaborate and work together so that we can provide the best outcomes for all of the participants in these mass tort environment. So again, I appreciate everybody for your time on the panel. Appreciate all the attendees for being with us today, and I look forward to seeing some of you in person, hopefully in the next couple months. So, a nice meeting everybody. So thank you.
Thanks.
Thanks, everybody.